Okay, so welcome everyone to the second episode of this podcast series called Environmental Justice Litigation. This podcast series is a part of the student project at the University of Oslo. My name is Iva Svalina and my co-host is Konrad Sandvik. Konrad, who are we speaking today?
Well, today we are interviewing Christina Voigt. She's a professor of environmental law here at the University of Oslo. And I'm really looking forward to learning more about the relevant laws of the case at hand, and also to learn more about the actual judgment of the Supreme Court on this matter. So if you don't have anything to add, I think we'll just cut right to the interview.
Let's go.
So today we are joined by an expert in international law, Dr. Christina Voigt, professor at the University of Oslo, Department of Public and International Law. So thank you so much for being with us here today, Christina.
It's a pleasure being here.
Thank you. And first off, can you just give us a brief explanation what the Norwegian climate lawsuit was from your perspective and how it unfolded in the Norwegian court system?
Sure. I mean, the lawsuit concerned a number of petroleum exploration licenses that were provided by the government in 2010, I believe. And the question was whether the lawmaker, by issuing or approving these licenses, violated a new provision, a fairly new provision in the Norwegian constitution, paragraph 112, which in short term establishes a right for every person to a healthy environment and to live in healthy environmental conditions. The claimants tried this case in several instances in the Norwegian court system, and they did not win through all the instances. It went all the way to the Norwegian Supreme Court, and the Norwegian Supreme Court established that these licenses did not violate this particular constitutional provision. That part of the decision was there was no dissents, but a second part concerned whether the government had violated certain procedural provisions, and here the court was divided, where some of the judges, three judges, actually found that the government would or should have had an environmental impact assessment to a larger degree, taking into account the impacts of climate change before issuing the licenses. All in all, the judgment was unfortunate, but it was not surprising. It was something that, given the Norwegian legal history and nature, was expected. I would have been very surprised if it had been differently. It would have been welcome, but it wasn't such a big surprise that it was what it was in the end.
Can you tell us a little bit about the current Norwegian climate targets and what legal measures Norway has adopted to achieve those targets? How can we connect those targets with the obligation in the Article 112 of the Constitution?
Well, Norway has its own Climate Protection Act, its climate law, where it sets out its obligation, which currently I believe stands still at 50% in 2030 and aiming at climate neutrality in 2050. But it of course is highly influenced by the European decision making, and the new European Green Deal now has raised its ambition to 25%, and Norway is following suit in this regard. The main measure to implement this target is, of course, the emission trading scheme, the European emissions trading scheme, under which Norway participates. There is a number of different sectors and industries that are covered by the emissions trading scheme, and the scheme sets a cap for emissions. And if companies do not comply with that cap, they can actually either buy additional allowances or have to pay a fine. That's the central regulatory measure, but around it it's a whole host of other measures, especially for those sectors that are not captured by the emissions trading scheme that applies to transport, that applies to agriculture, for example, buildings and so forth, where we have a whole range of different sector-specific regulations. In addition, there's a CO2 tax on some industries, which complements the European emissions trading scheme. But it's very difficult to explain this all in a very brief or short time. But what I'm trying to say is that the climate goals are supported by many different regulatory instruments.
Thank you. And going back to the lawsuit, the case here was the dispute was about some oil licenses in a new section of the Barents Sea, and I was wondering if you can give us some information of how they open a new field for oil drilling. What kind of considerations does the government have to take when they decide whether a new area should be licensed for oil drilling?
That's not exactly my area of expertise. I could give you a very general overview, but I'm sure there are others who could go into the details of the Petroleum Act that sets out the requirements. The only thing is, what wasn't obeyed by the government was an in-depth environmental impact assessment that actually does take into account the effects on climate change, the global effects on climate change by new exploration activities. And that's something that the Supreme Court came back to. But all the detailed procedural steps that would have to be taken for new oil explorations, that's something that is not exactly my field of expertise.
Yeah, no worries. You actually isolated the point we wanted to pardon the pun, drill into, which is the fact that we are making sort of an environmental impact report, but only accounting for how these emissions or for the emissions that would come in within Norway's borders, and not from the carbon that we are exporting to be burnt elsewhere. Could you talk a little bit about that dynamic?
Yeah, I mean, that of course was the core issue of the case, because the oil exploration licenses, once they're handed out, and in the meantime they all have been handed out, they lead to a right then also to start exploration and the actual production of oil and gas reserves that are found in these areas. Now, as we know, most of the produced oil and gas products in Norway are exported, and whatever happens with these products, they can be combusted and burned, or can be used for plastic production, for example. Whatever happens to these products and whatever environmental impact they have outside the Norwegian territory is not part of the Norwegian sovereign concern, primarily under international environmental law, but also, of course, that's how national laws are made. But the question is, does Norway have a responsibility by contributing to overall increased emission by kind of, starting the supply chain? You take out these products here, you sell them to somewhere else they're being burned and emit greenhouse gas emissions. And there is a causal chain in that. And the real core question is, what is Norway's responsibility for starting that causal chain by producing these oil and gas here and then selling it? And also partly another part of the question is, how does that relate to the overall economic structure of Norway, where the income is so much based on the income from these oil exports. The whole economy is based on that, and should therefore Norway also take a responsibility for the consequences of that activity in that sector.
Yeah, and from what I understood, it has a base in the Paris Agreement that you are only accounting for the emissions where they are combusted, as to avoid double counting and the like. But could you comment on how that existing framework and system is actually quite beneficial to an oil exporter like Norway, where we can seem very green in our emissions, but we are actually a larger contributor to climate change if you look at the supply lines, for instance?
Yeah, it's not just a larger contributor. I mean, it's 10 times as much. The emissions exported or that are resulting from exported products are 10 times as much as the emissions in Norway. So it's not just larger, it's a significant contribution elsewhere. Now, in the Paris Agreement, it's not written anywhere in the Paris Agreement explicitly that you only have to account for your territorial emissions. It's the underlying understanding of state sovereignty, and that you only have jurisdiction over your territory. That's where you can control measures. That's where you have the possibility to adopt laws and to enforce them. And what happens outside your territory is not necessarily something that concerns you and shouldn't concern you. There is an exception to that. That's the customary rule under international law, that no state can use its territory in a way to cause environmental harm to other states or to areas beyond national jurisdiction. But that issue is not necessarily reflected in the accounting requirements under the Paris Agreement, where each state puts forward a nationally determined contribution and where it puts in measures that it aims to adopt on its own territory. But even there are exceptions. For example, many parties put in, for example, trade measures, carbon trading, which necessarily is cross-boundary. So there is a cross-boundary element, which is saying, it's not only what you do on your territory, you can also trade. But when it comes to accounting for exported emissions that result from exported products, that is something that the Paris Agreement doesn't deal with.
But although this is not mentioned in the Paris Agreement, there are other things in the Paris Agreement which Supreme Court mentioned as an instrument which legally obliges Norway. But Supreme Court still didn't give it any additional weight when it was explaining the Article 112 of the Constitution. Can you comment a little bit about that?
Yeah, I'm happy to, and I did write a little bit about this as well in an article that I published earlier this year. The Supreme Court did recognize the Paris Agreement as a legally binding agreement under international law, under which Norway has certain obligations, but it never, made that link about what these obligations actually are and what it means for Norwegian oil policy or climate policy, if you want to look at it, two sides of the same coin. Because the Paris Agreement sets out an overall climate goal, amongst other things, of course. And in order to keep global warming to well below 2 degrees or even 1.5 degrees, there is no other way than achieving carbon neutrality by around 2050. And in order to get there, it's very clear that we cannot add more carbon into the atmosphere. So every program, every policy, every legal avenue that allows continued carbon dependency is countering the overall goal of the Paris Agreement. That's something the Supreme Court could have delved into, but it didn't. But it did draw in science, which says exactly the same, and it supports the Paris Agreement, but it didn't make the link between what the agreement purpose is and what science says to what kind of climate policies are commensurate to that science. And another aspect which I worked quite a lot on is that parties have to put forward an NDC, a nationally determined contribution, every 5 years. And every 5 years it has to raise in its level of ambition. But each NDC also has to amount or has to reflect each party's highest possible ambition. And the question is, what is the highest possible ambition? It's not defined anywhere in the Paris Agreement. Nobody checks it. But the legal requirement is there, at least as an obligation of conduct. And there the argument can be made that, Norway could have done better. Basically, that's not the highest possible ambition if you just continue with, oil exploration and just sell that stuff, burn somewhere else. Highest possible ambition looks different. You could at least request from those that buy the Norwegian oil that they have carbon capture and storage capacities, or that they regulate the emissions. Some of Norwegian oil goes to or gas goes to China, where we have very little regulation. So Norway could impose export restrictions or export demands or requirements, requiring from those that actually buy Norwegian oil and gas that they do not contribute to overall emissions. How they do it is their thing, but at least they should make sure that this stuff doesn't go into the atmosphere, but maybe is somewhere captured in the ground. That would be an easy step. but Norway doesn't do that at all. And that could be a way to comply with highest possible ambition. If you don't say, no, we have to stop entirely or something. There are lots of ways in between to say we can do better, and this is the way we do it.
And this is actually sort of related to what we plan to ask you a bit later, but we can bring it up now since it fits so nicely, is that a lot of people still argue that Norwegian gas and oil are part of the solution to the climate crisis. That's the wording they use, because it can help phase out, for instance, coal in the rest of Europe. At least our gas can. And but as you say, we should have at least some standards to that. It seems like that argument is only thrown out. We should produce as much oil and gas as we can and hope that it helps the environmental crisis in the right direction.
Yeah, I mean, we've heard this argument many times. In addition to the argument, whatever Norway does is only a little bit to the. But that doesn't matter. In my view, it doesn't matter. Every contribution to the solution matters. And Norway can do better, especially, not relying on that sector entirely for its economic growth. But I think that argument that Norway replaces coal in Europe, it is not substantiated. It is not supported. We had some reports by the oil industry that said exactly that, but you have to wonder, how objective they are. But there is also a lot of scientific input and consensus that this is actually not the case, because the decarbonization in Europe is going so fast these days, especially with the 55 Fit for 55 package, that it does not depend on Norwegian oil and gas imports. It's just phasing out coal as we speak and switching to renewables. And there's no switch in from the Norwegian oil and gas in that Fit for 55 package. So I think Norway is just lagging behind by delaying that shift to renewables by still supplying oil and gas into that market.
It's a bit of a self-serving hypothesis as well. I guess that we want to keep going with oil, but and therefore we want to justify it by some measure, I guess. And we'll get back to this as well. But since we were talking about the Article 112 and combustion of the oil abroad, I was wondering if you had any input on the Supreme Court's decision that we should, in a way, care about how emissions from oil combusted abroad changes the climate, but only so far as that climate change impacts Norway. And if you could also speak to some of that dynamic, what that means, and how it maybe differs from the city and appellate court, if you have that.
Yeah, I mean, this is actually, and again, I wrote about this a little bit. I picked it up in my article. This is actually a very interesting part of the judgment, and it's slightly unexplored, but it opens, widely an interesting door for future climate litigation. Because if the Supreme Court said, well, actually these contributions to overall climate change could be harmful, and Norway could be liable for that if it causes climate damages in Norway. Now, of course, it's not that particular emission, but it's the general contribution to the problem. But by the time climate change becomes tangible here in Norway, and that seems to be just around the corner, given that the heat waves and floods and everything that we had in other parts of Europe this summer, Norway is a little bit protected because of its geographical location, but it's going to come, and it's going to hit Norway as well as it's right now hitting other countries. And by that time, where climate change impacts Norway and Norwegian territory and leads to climate damages, then the question is, isn't that also part caused and contributed by Norway? And this is exactly what the judgment says. It only said right now that's not the case. It's not really clear, but in my view, it's just a matter of time. It's not a matter of whether and not, it's a matter of when. And by then, that door was opened by the Supreme Court for further climate litigation.
Yes, and in connection with that, we saw that one of the arguments used by the plaintiffs was that fossil resources that may be exploited globally in order to comply with the Paris Agreement have already been found, and that there is no room for petroleum produced under this licensing decision. How do you perceive this argument?
I mean, this is what science tells us. It's what the plaintiff said, a couple of years ago, but that's what we've heard only this year from the International Energy Agency's Director General, from the United Nations Director General, Antonio Guterres himself. They all keep on saying the consistent message that the oil that the atmosphere can store has been burned already. We have no capacity to burn more, because what is in the pipeline up to in the atmosphere, there's an inertia that will continue the concentrations in the atmosphere for many, many years to come. So we already have contributed to climate change that will come in the future, but every single ton we're adding now is just raising the increasing concentration and raising the future temperature increases. And science and the highest political level is absolutely clear, saying there's no way of adding more, and yet we do. Norway does, many others do. So yes. that argument is very central, but it is very disappointing that it doesn't yet find more political will and support to follow it through.
Yes, when you mentioned it, that I wanted to ask you to comment briefly on the IPCC current work on the 6th assessment report and the recently published findings of the Working Group 1, since we also saw that Supreme Court recognized the seriousness of the climate change crisis by referring to the IPCC's findings, but still did not draw a link between those findings and the possible consequences which that can have on the interpretation of the Article 112.
Yeah, exactly. No, I completely agree with that. It was interesting to see the Supreme Court actually going into these reports by the IPCC, and that was good. And it seemed to understand the seriousness, what we can read off these reports, but then translating into what it means to interpret 112. There seemed to be, a complete cut, that there was no link made between the science or the Paris Agreement and what it means in the term of interpretation. Maybe as the hensyn, whatever that is in Norwegian, the objectives that you have to take into account when you give meaning to the terms of a provision, and here it's a constitutional provision which hadn't been interpreted before. But back to the IPC AR6, the first part of the 6th assessment report, which came out about 2 months or 1 month ago. Time is weird these days. And it's interesting. There's several things, of course, in it, and this part 2 and part 3 will come next year. So the first part only deals with the physical basis of climate change, and next year we'll get a report on the impacts of climate change, and another one on the mitigation action required. So these 2 reports next year will be even more important, and probably will be picked up by media and discussions anywhere. But this first part of the 6th assessment report said very clearly that it is without doubt, absolutely without doubt, that humans are causing global warming. And scientists don't use the word certain or without doubt. So that is extraordinary that they did this in this report. And then they don't really say what needs to be done. This comes next year, but they're working with 5 emission scenarios about how the world can look like between now and the end of the century. And all 5 scenarios are possible. They're not unreasonable, unrealistic scenarios. But they say the world has basically, different choices to make. And depending on the choices, we can keep temperature increases to somewhere to 2 degrees or even well below 2 degrees, or they can go all the way up to 5.7 degrees. That is the highest point in these 5 scenarios. And it's very interesting to see what kind of action corresponds to these different scenarios. And if you look at the one scenario that stays below 2 degrees, that scenario says that right now, immediately, we have to drastically and rapidly cut emissions. and to get to somewhere close to get to net zero emissions by 2050, and then stay negative below zero until the end of the century. And these are really drastic changes that are required in order to make that happen. But it's the only scenario that would correspond to the Paris Agreement and to what science said would need to be done. So that's a very important message by the IPCC in its latest report.
So how, maybe a difficult question, but how would a better ruling look from the Supreme Court? What could be decided in the courts with respect to these specific oil licenses and Section 112?
Well, and that's interesting. You could write a shadow judgment, and I actually started doing that, and then I ran out of time. But it might be a very interesting exercise, maybe for some students. Write a shadow judgment. Given the arguments put forward, what else or what different judgment could the Supreme Court have rendered? Well, first of all, it could have, in a more obiter dictum style, where it doesn't go into the issue of the case, but makes more general observations about how climate change and the legal system interact. It could have done that in a more consistent, coherent, and timely manner than what it did, just saying, okay, this is what science says, but then we do something else. But in terms of the actual finding on the case, I think there was a possibility to say, well, first of all, there actually is a right when it says that each person has a right to a clean and healthy environment, that actually is a right that can be judicially reviewed. That's something the judgment didn't say, the court didn't say. It says it's an obligation for the government to carry out certain acts and activities, but it didn't go that far to say explicitly that it said explicitly that's not a right. And I think that is something very difficult to understand when the Constitution, in words said every person has a right to do. So that's something which is really unfortunate. But in terms of the question whether issuing these exploration licenses violated that right or the duty, it could have gone further. It could have looked at the overall impact of Norway to the climate problem. And even if it didn't want to say that these licenses were illegal or violated that right, it could have said that Norway could have put, export restrictions on these products when selling this to other countries, in order to ensure that Norway doesn't contribute to overall emissions, by making sure that wherever it sells Norwegian oil and gas, then has the obligation to make sure that it doesn't increase emissions by whatever technology or planting forests or whatever they do, that they have to neutralize and offset these additional emissions. So there are many possibilities that the court could have pointed to. It didn't have to say it itself, but it could have played the ball back to the lawmaker and saying, please revisit your law, please revisit the regulation around this and take into account the overall contribution that Norway has. So that the court doesn't appear as a lawmaker, but it lives up to its judicial function of judicial review, and sends it back to the parliament with the request to revisit its legal framework.
And I would love to talk more about the issue of whether it's actually a right, because it's baffling to me that the Section 112 can start with everyone has the right to, and then it's still not you're still not sure whether it actually is a right or not. Explain how that happens.
Oh no, I don't. I don't want to justify the Supreme Court in this situation. No, I'm sorry, it was more of a joke here. But I've been asked this question many times because I'm, active in many international fora. And one of the first questions is like, it says it's a right, how can the court say it's not a right? And it's very, very difficult to justify. The reasons that the Supreme Court put forward were linked to the travaux préparatoires, the previous article and its history, and then, trying to find some sort of reasons of why that's then also applied to this new formulation, which actually explicitly says each person has a right. Every person has a right. So it's a very intricate argumentation that the court has done, and I think it did not do itself any favor by doing what it did. And it's very, very difficult to justify. And it didn't, other than travaux préparatoires, so preparatory works, it didn't provide any other justification for why it is not a right, but just a duty.
But what we saw from the Supreme Court judgment is that the Supreme Court said that in order for courts to set aside a legislative decision, it must be established that duties under Article 112 have been grossly neglected. And do you think that this high standard will affect the use of article in the future? Can we expect new lawsuits?
I think so. I mean, first of all, the first part to your question, yes, I think it will affect future lawsuits. And the second question, can we expect future lawsuits? Well, we have to see. But the court actually said several things. It said it can review the government, Article 112 can be used to establish a standard of action if the lawmaker has not acted at all. If the parliament, for example, had not had any, adopted any climate law or regulation at all, then article would come in and 112 come in and fill that gap. And here the question is, has the lawmaker actually acted on exported emissions? Because to my knowledge, there is no regulation, no law at all that deals with the exported emissions, so the emissions from the export of oil and gas products. So you could actually make the argument that this is an area where the lawmaker has not acted and where 112 would come in and fill that gap, because the lawmaker has not acted. And then the second aspect is Article 112 can be the basis for judicial review if the parliament has grossly neglected its duties under Article 112, third part to enact effective measures. And here, that grossly neglected element or requirement is not explained, where that threshold lies, where is the neglect, when does the neglect become a gross neglect? That is not clear, and that may be the issue of future law, future cases, to define more clearly what is the threshold of gross neglect. What does the parliament have to do in order to grossly neglect something? And it's probably never fulfilled. But I think in terms of climate change and the science, the conclusive science that we have, a lawmaker that sets aside these considerations, despite a large part of the population, youth and so forth, pushing for it, and if a lawmaker says, oh, we don't take this into account, I think that could be considered a gross neglect, also when it refers to exported emissions. But this is something for years to come, and maybe we have other lawsuits that shed more light on defining more clearly where exactly this threshold lies.
Because the threshold of gross negligence, is that a term from criminal law, or?
If you want me to provide a brief answer, I think it would have been very helpful if the court had said where it has this gross negligence from. Where does that standard come from? Maybe from criminal law, maybe somewhere else, maybe from earlier cases. But it said nothing. It just came with this threshold without, linking it to any other legal area or precedents. And that would have been helpful, because then you could actually have worked with it. But I do invite, law students and my colleagues at the law faculty to, shed more light on gross neglect and what it means and when it is, passed and when not. So there's a lot of research to be done.
Because at least the way I understand it, it's a high threshold for when the court should intervene then in what they deem like a political decision. They say that the politicians should do this, the decision should be made in parliament, and it's a very high bar for the court to intervene in these kind of matters. And in that, I would also like to talk more about the article that you've stated you wrote, and we've touched on some points from there already. And I would like to quote some of it here, that you say that opponents of the case had argued that asking the Supreme Court to rule on the legality of petroleum licenses is trespassing the realm of politics. This is the article of the climate judgment of the Norwegian Supreme Court, aligning the law with politics. I'm advising everyone to read it. It's a great read, and not too hard as a non-law student, I might add. But you also say that yet by aligning the content of the Constitution with prevailing politics, the Supreme Court ultimately rendered a highly political decision. And we would love to hear some more about your views on that.
Yeah, well, it's actually, it's the title of the entire article, that that there was a lot of debate for the entire time that lawsuit made its straight way through the different courts, that this is not an issue for courts, but it's a political issue, and you have the division of power, and courts have no role in that, and so forth. Because they shouldn't be political, they should just apply the law and not deal with politics. And my view is that in the end, the court actually did render a highly political judgment, because it used the law in a way to carve out a significant discretion for the lawmaker to do basically whatever it wants, as long as it has done something. The Supreme Court said it has complied with Article 112, because then it has not grossly neglected its duty. And it doesn't matter what it did, as long as it did something on climate law, whatever the level of ambition, it has complied. And this is the carve out, where I say that the Supreme Court used the law in order to align it with the prevailing politics. It carved out that space for politics to just continue pretty much business as usual. And the bottom line is, as we talked about earlier, that the Supreme Court could have done differently. It could have done differently. It could have, for example, set that threshold much lower. It could have said, the lawmaker has to take into account climate change. It could have said there is a right, and the right is violated. If individuals, if people, if citizens have to fear about their future, their environment, their rights. So it could have done many different ways that would have maybe infringed a little bit on the prevailing politics, but it didn't.
Yes, and from what we saw, the Norwegian Supreme Court did not mention the right of future generations when considering Article 112. But exciting things about that are happening on the international stage currently, where Vanuatu requested the UN General Assembly to ask for ICJ opinion regarding the present and future generations' right to be protected from climate change. And what do you think that this can mean for the development of the international law regarding this right?
Yeah. Well, just one step back to the Supreme Court, just one more time, one last, I don't know, maybe I have more questions, but on this issue, one last word. This is another hardly justifiable aspect of the judgment, where it is written explicitly in Article 112, first paragraph, that this right applies to current and future generations. And with not a single word did the judgment, did the court look into the intertemporal aspect of oil exploration and how that could affect to a higher detriment the people that are young today but live into the realm of climate change impacts. Not a single word. And I think this is also not living up to the mandate that the Supreme Court has as the guardian of the Constitution. Really, it should have at least analyzed this and taken it into account in the interpretation of the lawmaker's duty under Article 112, and that it didn't is just a very disappointing aspect. But as you said, there's a lot of things happening elsewhere, and you pointed to Vanuatu's recent initiative to ask the United Nations General Assembly for a request to the International Court of Justice to render an advisory opinion. And the possible question. It's not quite clear entirely what question will be asked and whether that goes forward. But the question is, what are states' obligation to protect present and future generations from the impact of climate change? And that's a very broad question, but it has exactly that intertemporal aspect to it, and intergenerational justice aspect. But that's not the only case. We have also currently a number of cases pending at the European Court of Justice on climate change. Most of them, if not all of them, also have the aspect that are being put forward by children, by young people. One is put forward by elderly ladies from Switzerland, but the other three, at least two of them, are put forward by young people who are worried about the impact of climate change on their right to life and private life already now, but even more so in the future. So there is this aspect of not future generations, but of generations of people that are young today, but live into a different future. And it has this intertemporal aspect as well. So we will see what the European Court of Justice has to say, or whether Vanuatu's request is successful. But there's a strong push to involve international courts and regional courts on the issue of climate change and on the issue of the intergenerational aspect of it.
Yeah, and could you speak a bit more about the state of climate lawsuits other places in the world? For instance, we saw that Royal Dutch Shell was ordered to cut their emissions more than they planned, for instance. And what parallels can you draw from the Norwegian case to other cases happening in other countries?
Well, first of all, climate litigation is a wave that washes all over the world right now, because we see climate cases being brought to courts in many countries, both global north, global south. There's just this enormous engagement of the judiciary in the question of climate change. And it's not surprising because, as I said, the science is clear, but political willingness is lagging. And in that situation, the third pillar of power comes squarely into the picture. And this is what courts are there for. They are there to hold governments accountable to their rights and to their duties and their obligations towards their citizens and towards each other. And if they don't live up to that, then that's an issue for courts. So we see this in many countries. And you alluded to a recent case against Royal Dutch Royal Shell in the Netherlands, which was an interesting case because it was one of the first ones against a private company. And here the first instance court in The Hague in the Netherlands found that Royal Dutch Shell was violating a duty of care, an unwritten duty of care in Dutch tort law. And that duty of care was interpreted taking into account science, the IPCC, but also the Paris Agreement, but also human rights obligations. It doesn't mean that this applies to Royal Dutch Shell as a corporate actor, but the duty of care applies to Royal Dutch Shell. And in order to give meaning and content to that duty, the court drew in all these other aspects and then ordered Royal Dutch Shell to cut its emissions, not just in the Netherlands, but in its entire supply chain and all its dependencies in about 120 countries, which is quite a significant finding. But this is just one example. Another one is the German Federal Constitutional Court rendered a judgment earlier this year on the violation of liberty rights of young people today, which will grow into a future where the freedoms that we have these days and take for granted, like buying t-shirts everywhere, and buying stuff and traveling everywhere, these freedoms will be drastically constrained in the future. If we mean climate change action seriously, these young people today, when they grow older, they will not have the same freedoms. And that is discriminatory in an intertemporal aspect. They will have to live in a carbon constrained future, something that we don't do right now, but they will have to do if they will have to bear the burden. And the court said this is discriminating and is violating their rights, and at least the burden should be allocated equally from now on until 2050.
And compared to the Dutch case, then the Norwegian Supreme Court seems very conservative, since they had like a written out right to climate and a climate paragraph, and they still did not get like a very pro-climate decision out of the lawsuit. Does that mean that the Norwegian judiciary is quite conservative in comparison to the Dutch? Or do we have perhaps like a soft spot for oil, being an oil nation?
Well, I won't comment on whether the Norwegian Supreme Court judges have a soft spot for oil. This is something I will not,
perhaps the Norwegian people in general. I think that's.
But what I think is that, I mean, I am in many of these international networks of judges where I see them talking to each other and meeting in seminars, explaining to each other their judgment and why they did what they did, and they're critical to each other. It's not that they all say, oh, we'll do the same, this sounds no, they're critical, but they learn from each other and they try to understand what you. And I've never seen any Norwegian judge in these networks, not a single one. There are judges from America, from Brazil, from everywhere. But maybe, they're maybe not that looped into these international networks. They were all educated at the time where environmental or climate law were not part of the curriculum at the law faculty. I teach this now. So every young law student has to at least take environmental law. And if they want to, they can also have courses in climate law. That wasn't the case when the current Supreme Court judges were, going to law school. But maybe it's also the general culture here, legal culture in Norway, and the understanding of what the Supreme Court does. Maybe it doesn't really see itself as a guardian of the Constitution, and it has a more reluctant approach to it. I mean, I'm trained in Germany, where we have a constitutional court. It's so ingrained in the legal culture that yes, there is a court that looks at whether the Constitution is complied with. But here it's a bit more of an organic situation. So there may be different reasons why it is rather conservative, but maybe it's a matter of time. It's a matter of generations. Maybe there are new people coming in that may look at the law differently and maybe with more open eyes and concerns about what impacts actually the rights and duties of the state and the citizens respectively.
It might be a question of getting more radical judges, perhaps, or more climate aware judges, is sort of a summation of that.
I don't think radical is not the right thing. I mean, you probably will
no,
never
I'm regretting using that word, because it's not, I would not consider that radical in today's climate.
Yeah, that's what exactly what I was about to say. You don't have to be radical, just you have to be informed. You just have to be able to read science and scientific reports, and have a logical mind to put one and one together, and how that then translates into the law. So I don't see anything radical about this at all. You just have to be a citizen, really, who is concerned and who is informed and lives up to its citizens' duty to its current fellow citizens, but in particular to those that are young today and vulnerable and not part of the decision-making process. Children have no real say in political decisions, other than taking to the streets, and that's not very effective either to a certain extent. But I think it's more of a growing awareness of what is climate change, what are these challenges that we are facing, and how does that translate into the law. It's not just something outside the law that other people deal with. It is part and parcel of the legal profession as well, and I think that's something that probably will sink in soon enough.
But do you think it's hard for the current Supreme Court to make a more climate-friendly decision on this issue because of the political climate in Norway, where let's say the people that voted for the government we've had for now 8 years use the argument of Norwegian oil and gas being part of the solution, and that's kind of the framework of probably like half of the population. So does that make it more difficult for the Supreme Court to act against that?
Well, on a personal, individual level, and a court is always a number of individuals, and by the end of the day, it's those persons on the court that have to make these decisions, and they they reflect their personal value system there as well, and in their education and of course the law, but there's also personal values and certain ethics. And I do think there's a certain alignment between the value system on the court and the majority of people here. But by the end of the day, the court should be independent. It should be neutral and objective and apply the law to the facts and protect rights if it recognizes that there are rights in an independent and legally dutiful and diligent manner. And these personal preferences shouldn't really play a role. If the government, if the parliament violates a right of a citizen by adopting a certain act or by rendering a certain decision, then it should be the court's prerogative to say that here a threshold was crossed, or a line was crossed, and a right was violated, and the parliament or the government acted unlawfully. That should always be the case. If that's not possible, you have to question the whole meaning of the third pillar of power and the balance of power.
But what you mentioned makes us wonder, what is the role of the legal system in the climate activist? And what do you think are benefits and limitations of using the legal system as an activist's tool?
It's difficult to say in general terms. You may have to look at each case at the time. And there are, of course, benefits in terms of raising awareness, in terms of thinking about what does the law actually say about climate change? Are there obligations? Are there duties? Are there rights that need protected that could be violated by certain climate-friendly decisions or politics or laws? So that shedding the spotlight on a revision or interpretation or use of the legal system is very important, because I think we actually have entered the time of law. We had the time of science and politics, but this is that's all clear. But now it's about, how can we make this transition by the use of law, by legislation as well. But if legislation isn't enough, then also by litigation. But of course, there are downsides as well. I mean, you may lose a case like Norway, and then you're back to the start, back to zero, or you may actually contribute to legal developments by judgments that go in the wrong direction. You can, there are lots of challenges that come along with it. It could also be a perverse incentive for governments to take more ambitious action, because they say, oh no, we wait until we are told by a court, and that can be many years. So until then, we just do business as usual. So there's also that downside of it, and probably many more. But it's as everything in life, it's a pro and con balance. And I don't think there's a absolute benefit or an absolute disadvantage, but it's a tool in the rule of law. If you're serious about applying the rule of law and the division of power, then courts and the judicial system has to play an equally important role as the lawmaker and the executive.
So I think that's all we're going to have time for today. But I think that was a really interesting conversation. So thank you for taking the time. It was really a pleasure.
Thank you so much. And thank you for your questions. They were excellent and very, very deep. I enjoyed reading them when I got them yesterday, and I really enjoyed having this conversation with you, trying to answer them. Thank you so much.
Thank you.
Thank you. Right, so that was some kind words from Christina there at the end, and of course a very interesting interview. So I don't know, Iva, what you feel that we got out of this conversation?
Well, I think we got a lot of useful information. I would maybe mention, from my perspective, it was interesting to hear that the Professor Voigt thinks that Norwegian government could have done more when it comes to combustions abroad. They could have imposed export restrictions so that the countries which are getting Norwegian oil and gas do not contribute to global emissions, but also that Supreme Court could have said that Norwegian government should have done that, but they also missed that opportunity. And I think it's also interesting that the Professor Voigt said that this could open the door for future litigation when climate change hits Norway. So yes, we'll see. Will that happen? What do you think?
I think it's also, you get the sense of haste when she talks about the inertia of climate emissions. Like there's already been released so much CO2 that that hasn't caused warming yet, but will cause it further in the future, and we're running out of time to make the big needed decisions on this area. So, but we had some disappointing realizations about the court's decision in this area, like the standards they set and how that might be a hindrance in the future. What kind of precedents there came from this case, but nevertheless, I think it was very interesting, and I'm looking forward to do more of these interviews. So thank you all for listening, and we hope to see you in the next episode.